Commission, I would ask for those to be made part of the record
Yes.
of this application. Likewise, the transcripts of this meeting and the Planning Commission meeting last week, we would ask for those to be part of the record. Again, just
Yes.
before I forget to do that.
And before I forget, when you were talking earlier, you said that the planning commission meeting was January 20th, but it was actually January 30th.
No, the Planning Commission meeting was January 30th. I believe Mr. Mullins' letter offering the extension is dated January 20th. But you correctly pointed out to me that it wasn't emailed. The letter is dated the 20th, I believe, but it wasn't emailed to the township until the 21st or the 23rd. I'm not sure which. Nevertheless, there is an offer before the township for an unlimited extension of time under the saldo and under section 508 of the MPC for your review and action on the plan. I believe the law is clear that when an applicant grants that offer of an extension, the municipality should accept it. But again, that's entirely within your hands at this point in time. We have, as I said, had the opportunity to go through Mr. Ulrich's letter. We believe that we can comply with the overwhelming majority of those comments. I noted as much in a letter to you that I delivered to Ms. Kushto today. I don't know if that letter has been forwarded along to you. Happy to discuss any or all of Norm's comments. Up to the board at this point in time as to how you'd like to proceed.
You did ask a couple questions that I had passed on to Sean, one of them being when the plans were provided to Montgomery County Planning Commission.
Yeah, I hand-delivered the plans, that is like a scroll set of the north and south plans, as well as a thumb drive with all of the sundry reports on it, on December 9th to MCPC in Norristown.
Okay, and then I think you had further contact from them?
Yes, about 2 weeks ago, we had reached out to MCPC to see the status of the plan review, and were told that they could not locate those physical plans. At that point, we made an appointment for MCPC staff to come and collect everything on a thumb drive.
And do you know when they collected that?
I want to say that was January 27th, I think a Monday.
That they collected it? Okay.
Correct.
But they lost that big scroll of plans?
Yes.
Okay. Mike had also asked from you when it was provided to the township's traffic engineer.
Checked my emails earlier today. It was sent via Dropbox to Traffic Planning and Design on January 2nd.
Okay. Just to answer those questions that you had asked.
So I just want to make sure I understand that. So the application was filed on or about November 1st, and it wasn't delivered to MCPC until December 9th. Is that correct?
That's correct.
And it wasn't sent to Traffic Planning and Design until January 2nd.
Correct.
Okay. And do we know the date on which it was sent to the fire marshal?
It is not, we do not have a fire marshal appointed on staff at this time.
Okay. So LTL has made the comment that the fire marshal should review the plan and offer comments. How does that process normally work in the township?
As a matter of personnel, I can't discuss, but I can say that we are in the process of interviewing a fire marshal. I can't provide a date when a fire marshal will be available to review the plan.
Okay. So how do things, I'm sorry, this may sound like a deposition, it's not intended that way, but how do things usually work in the township when land development applications are filed and they need to be reviewed by somebody with a fire hat?
I can't speak to past practices. I started here in September.
Okay.
This is the first land development, certainly of this size, that I've seen in my time here.
Okay. So as we sit here tonight, there has been, nobody with a fire hat has reviewed the plans.
With a fire hat?
I'm just trying to, I'm being colloquial, but nobody who would be able to review the plans from the perspective of a fire marshal has reviewed the plans.
No fire marshal has reviewed the plans.
Okay. And my last question, Vicki, if I can just jump in, was how much of the $33,000 in escrow has been expended? Or another way of asking that is how much remains?
So all of the money has been deposited into an escrow account. This gets into a matter of internal accounting. We've received invoices from both LPL and CKS for billable time toward that escrow. That money will not be released until the supervisors meeting next week when we do a check run.
And finally, I understand why no fire marshal review has taken place, but is there a reason why the plans weren't forwarded to TPD until January 2nd? That's 2 months after they were submitted.
At the time of their submission, the township did not have an appointed traffic engineer.
Okay. All right, those are all the background questions that I had. Again, we can certainly, I think before we start talking about the substance of the application, it makes sense to know the board's thoughts on the extension or answer any specific substantive questions that the board might have.
For me, I'm not ready to talk about an extension until we work through some of the other things. Then we'll get to the extension, the approval.
Okay. What other things, are there specific comments in the engineer's review letters that we should address? I know you probably haven't had a chance to go through the letter that I wrote, going through each of the 383 comments and noting which ones the applicant will comply with, which ones we think should be conditions of approval, so on and so forth. But if there are specific substantive issues that I or Susan or Tim can address, we're happy to do that.
Okay.
Well, I don't want to speak for the board,
Okay.
but I think what you're going to hear from the public this evening, just like you did at the planning commission meeting, is the concern about water and sewer.
So the water and
I think that's a good item to address.
So the water issue is easy enough to address. We will be seeking a permit from DRBC for the water supply. We think the law on this issue is clear. The Montgomery County Court of Common Pleas in 1980 examined the issue of whether or not DRBC regulations preempt municipal regulation of water, groundwater. And the Court of Common Pleas ruled that the DRBC does have preemption, and then the Commonwealth Court affirmed that. The Commonwealth Court more recently has examined the issue of preemption with regard to the Schuylkill River, Susquehanna River Basin Commission, and again found that preemption does exist. Regardless of the preemption issue, we have made it very clear that we will provide the groundwater data that ordinance number 2023-1 and ordinance 2024-3 require. We did not submit the phase 1 study with the preliminary plan application. That does not mean that we cannot provide the phase 1 study and the data that your ordinance would require but for preemption. We're happy to do that.
Do you have that information now?
We don't have that information, I mean, I don't have it with me this evening, but we're happy to provide that information as part of a revision and resubmission to the township. We're happy to provide that information in coordination with the application that will be made to DRBC. If the board denies the application under some theory that it wasn't submitted as part of a complete application, then we get back into this good faith discussion of why nobody from the township ever said, hey, where's your phase 1 study? So again, this is not a substantive issue. We have the ability to provide the data to the township. We believe that there is more than sufficient water to service this development. The rates are, I believe, 500. So we would have to check with our water consultant. We have Jeff Clark, who's a professional geologist, who would be able to come before the Planning Commission and talk, at the time that we submit his report, be able to come before the township and talk about what the results of the initial well tests were. We're happy to do the testing of the adjacent property owners.
Mike, do you think that would have been a good idea to bring to the planning commission? And then after they asked.
This is a preliminary application, and we were responding to comments that we had received from the consultants. That's what we were prepared to discuss
I
with the planning
understand that, but it
commission.
was clearly an issue for the PC, so it would have been an issue.
We didn't know it
for
was
us.
an issue for the planning commission until we got there last week. And I can tell you
So we're here
that
now, and
we've
you knew
checked,
it last week.
we have checked with our professional geologist and confirmed that his belief is that there is more than sufficient groundwater to service this development. That's what we're prepared to say this evening. We're also prepared to submit his report as part of a revision and resubmission.
So you went ahead, did these wells, didn't pull a permit from DRBC, and didn't know the township. Is that what I'm understanding right now?
Go ahead.
This is Tim Hendrick speaking. We worked with the township closely through the entire process. This ordinance that we just learned about that says we needed to test neighbors' wells and all that was adopted after all drilling was done.
That doesn't mean anything.
Well, how do we follow an ordinance that's not in place when you do the
It's
drilling?
advertised on the front of our website. Right now, it's been there. It's been there for.
Was it there 10 months ago when we did the drilling?
Oh, absolutely.
Okay.
Oh, it was 10 months ago when you did the drilling.
Yeah, it wasn't there. It wasn't there. We
No,
came in,
actually,
But
you,
10 months ago
Yeah,
is
yeah.
24.
it's 24, Tim. You actually drilled the wells in June of
correct.
23, right?
You have two ordinances.
So the
Which is one
first
that was
ordinance
dated
was
last
adopted
year?
in May.
Which was adopted last year more recently?
24, that's,
24 is the quality.
2403, that's the quality.
Is that testing the neighbors' wells and all of that?
Yeah.
That was brought up by the planning commission. That was not in effect. We worked with the township, we got a permit from the
Hold on a
township.
second, Tim, it was in effect. Quit saying it wasn't.
Okay,
It
your
was.
staff didn't, it's not even in your engineer's review letter.
My staff's not drilling wells, you are. It's your
We
job
can't-
to ask, Tim.
Yeah, we did. We met with the township.
Do you have that correspondence?
Yes,
we do.
yes, we actually do. So
Your engineer was on site. Not this
Okay.
engineer, the engineer you had back then. The manager you had back then was involved in the everybody was involved in the process. This was not done in the dark of night. We followed everything that everybody was aware of.
Well, our engineer is Norm. Were you on site?
No, he's not the water and sewer engineer. He's your civil engineer. Your water and sewer engineer is over here, and he just started, when did he start, in January? He started a month ago. So all you got rid of everybody that knew anything. We have correspondence, we'll provide it. We did everything we were told to
Don't
do.
you think you should have brought that here so we could see it? Because right now,
Is it our job to provide you what the township was provided with already?
we have.
You're the one
Yeah,
sitting
excuse me,
here admitting to
I'm gonna jump in here. We have a letter.
Mike, hang on, let him answer the question.
I have to
When
answer
you're
the
sitting
question
here
right now.
talking to me,
He said he has a
don't you
letter.
think you should have brought that to me instead of sitting here asking me to take your word for it?
We have a letter from our professional geologist, which I will forward to Ms. Kushto right now. And that professional geologist, Jeff Clark, confirms that in the spring and summer of 2023, test wells were drilled. The township's manager at that point in time was made aware of that, and I don't know if she was present on the
I'm sorry,
property.
when was it?
That was 2023, and the manager's name, I believe, was
I
Tracy
get-
Taggart.
I know that, but what was the date there?
What was the date in 23?
So we've got March 15, 2023, when the required 30-day drilling notification was provided to DRBC with DEP and Upper Frederick Township copy.
Okay, I got that. So when was the wells drilled?
The wells were drilled on July 25th, 2023 and August 10th, 2023. 3 6-inch diameter test wells were installed at approved locations on the
I
site.
get that, Mike, but what my concern is you gave us a 30-day notice and then didn't drill for 90 days.
Between
So you
November
should've submitted
30th,
another.
2023 and December 26, 2023, test wells TW3 and TW4 were converted to finished 10-inch diameter production wells. The wells were properly cased and grouted as per the approved pre-drilling plan. Well TW3 consists of 61 feet of 10-inch diameter steel well casing and a finished 10-inch diameter open rock borehole to a depth of 500 feet below ground surface. The final blown yield of the well was in excess of 500 gallons per minute. Well TW4 consists of 60 feet of 10-inch diameter steel well casing and a finished 10-inch diameter open rock borehole to a depth of 500 feet below ground surface. The final blown yield of that well was also in excess of 500 gallons per minute. I'll forward this letter to,
That's great.
Township right
My
now.
question is, so you told Ms. Tackett, the previous manager, that you were doing this, and she told you you didn't have to do a study? Is that what I'm to believe here? She didn't tell you there was an ordinance in June?
When was the ordinance adopted again?
It was in May
Of which year?
23.
Okay. And what was the second one adopted?
It was in 24.
Yeah, and that we filed, we
Tim,
worked
it
with,
doesn't matter when the wells are drilled.
Okay.
It has everything to do with when you're submitting your plan.
wouldn't your engineer typically enforce your ordinances?
I have no idea what went on there. I
Are we
wasn't here.
responsible for whether your engineer does his job correctly?
You're responsible to follow the ordinance.
gentlemen, I'm gonna interject here.
Yeah,
The
Not
law,
getting anywhere.
the law is clear, crystal clear. You have a duty of good faith. If you believed that something was not submitted, which needed to be submitted as part of the application, there was a good faith obligation to tell the applicant that. The Honeybrook Estates case, which I delivered to Ms.
We're not
Kushner,
worried
is
about
clear.
Honeybrook. Answer this, Mike. How long is that time frame that we have? Is there a time limit?
You have 90 days to review the application.
What day are we in here?
We're approaching the 90th day. if
We're not past the 90-day review, right? So you're finding out now.
You have, then you have to provide us with comments, and you have to provide a reasonable opportunity, once you've provided us with your review comments, for the applicant to resubmit plans and materials as identified in your review comments.
Well, Mike, in 804 that you talked about as far as the MTC went, it says that you need to submit a complete study or a complete plan set.
And if
Yours
you,
is not complete.
and if you believed that the application wasn't complete,
I had 90 days to tell you,
no,
which I'm in the 90
No.
days now.
no.
So, this isn't going anywhere. We need to move on from this discussion because we're not gonna get anywhere on this.
By the
Just
way,
trying to clear it up.
excuse me, I just want to be
Clearly
clear,
confused.
I have type 1 diabetes, and I'm eating an orange, so I'm not just being flippant.
Okay, so.
Munching on an orange and
Understood.
Can I just ask, you've used the term on us for good faith a lot.
All right.
Why would it not apply to you as well and Mr. Hendricks to, in good faith, supply the Phase 1 water study?
it does apply, and we have an obligation, once you identify issues in your review letters, or staff says, hey, wait a minute, we just received this application, we have a checklist, there's something on this checklist that you didn't submit, or there's something in the ordinance that's missing here, you have an obligation to tell us. And then we have an obligation to say, okay, here's our resubmission, we are responding to your comments, this is what it is. That's the iterative back and forth process that the municipalities planning code and the Commonwealth Court contemplate. It's not, oh, we're gonna wait until January 30th, until you get to a planning commission meeting to tell you, hey, we think that you forgot to submit something, and, oh, I was just gonna do that. We think that you forgot to submit something, and now we're going to deny it because you didn't submit it. I am not here to argue tonight whether or not that study is required or is not required. I have a legal position that I believe there may very well be DRBC preemption of the entire ordinance. What I'm here to tell you is, even if there is DRBC preemption, we are prepared to submit the data to the township that the ordinance calls for. But you have to give us the opportunity to do that. You have to identify that issue one way or another. And you then have to give us a reasonable opportunity to resubmit the application packet, plans, reports, studies, etc. We're happy to do that. But not if you deny the application summarily and say, too bad, we didn't identify this issue until January 30th or January 16th in the 383 comment review letter. Ma'am and gentlemen, your own engineer didn't identify the issue. Your own engineer said that the ordinance doesn't require this study. This is the gentleman who has served as the Upper Frederick Township engineer for a very long time. He said in his review letter that the study is not required. And you're going to deny this application because the applicant didn't submit the study? when the applicant is standing here before you saying, give us a reasonable opportunity to revise and resubmit, we'll give you the study. If that is the board's decision to reject the extension and deny the application under that fact pattern, when your own longtime engineer said in his review letter, the study's not required, then nothing I can do or say is going to persuade you differently.
Okay, so you talked to half of it, let's address the other half, please. You talked about water, let's talk about sewer.
Sanitary sewer is proposed to be a community on-lot system. Tim has had extensive interaction with the township, prior administrations, about public sewer, about whether the township would want to take dedication of a community on-lot system, excuse me. And our understanding is that the township has zero interest in any kind of public sewer. The township doesn't want to own the community on-lot system, so we are proposing a community on-lot system that will require DEP approval. Again, the state of the law is clear here. We've submitted a planning module packet that contemplates the community on-lot system. The engineer has raised comments with regard to grading and some saldo issues. Again, Morris v. South Coventry Township could not be clearer. When DEP permits are required, which one certainly would be for this, your obligation is to grant preliminary approval subject to the condition that we go get the permits that we need from DEP. We're prepared to pursue those permits. Again, this plan is going to change as we go through this iterative process. Roads will be shifted, units will be moved, some units will be eliminated altogether. And then once we have that preliminary approval, as the law contemplates, we'll move forward with the Part 2 permit at DEP to permit this wastewater treatment plant. We understand clearly that there is no interest in public ownership of the sewage facilities.
So I guess my question would be, where are you gonna discharge that into? Or where at?
We have met with the DEP, and they have approved where the discharge would go. We're way too early in the process. I mean, we have to see whether that becomes the ultimate location. I mean, we gotta have kind of some sense of order as to what happens. We gotta lock in the layout, the unit count, all of that, but we did meet with DEP. I can tell you that
Did you tell me who you met with at DEP?
No, our engineer did, and we can find out.
Because I called the DEP.
What?
I called the DEP.
Yeah, this is what, 2 years ago? Let me tell you, your last board wanted ownership of that sewer plant. So you guys are in power 14 months, and you're changing, that's fine. But I'm telling you, we're going down a totally different path. We were working in cooperation with your previous sewer and water engineer and the previous board, and they wanted ownership of the sewer plant. We met with DEP. The name of the engineer is Fred Ebert. He owns Ebert Engineering in Skippack. He met with DEP, came up with where they wanted the sewer to go. I'll tell you, they were in communication with the Frederick community here. Their sewer plant has to go away.
Why?
Because their sewer plant's failing. DEP told them as soon as something new is available, you gotta tie in something new and get rid of that plant. That plant doesn't work anymore.
The plant down,
Yeah,
the plant down here is no good anymore?
yeah. It's in the permit, it's public record, you can